We will go on the record in the matter 24 CF 169, State of Wisconsin versus Jennifer Rawls. The state appears through Assistant District Attorney, District Attorney Kevin Schmidt in person. We have Ryan Reed, Defense Counsel in person, as is Ms. Rawls. We're set today for a plea and sentencing. The parties have reached an agreement. Mr. Reed, can you please recite the agreement for the record?
Thank you, Your Honor. District Attorney Schmidt, can you state the offer on the record?
Yes. Split the link.
What you're hearing right now is not a routine plea deal. This is a slow burn financial crime with massive consequences. A first-time offender, nearly $90,000 taken from an employer, and a deal that stretches almost 15 years into the future. The tension here isn't just about guilt, it's about whether accountability can exist without prison. And that question is about to hang over every word spoken in this courtroom.
14 years? 8 months?
A little bit, yeah, 8 months.
Total of $87,850.94 stipulated restitution.
It's actually 88,000. It's just since she has 1,000 posts.
I know. Yeah, I see that. Okay. And
Yep.
monthly payments of $500. Yep.
So it's the plea to that one charge as is, and then we amend into theft by employees. We do the DJOC on the felony theft, and then convictions on the misdemeanors costs. On the felony, that's the payment plan is described in there. It's $500.
This is where the legal stakes become crystal clear. The defendant is staring at a felony theft charge that could mean prison, but the court is offering a narrow escape hatch. Pay every dollar back, on time, for over 14 years, and that felony never fully lands. Miss a payment? The deal collapses. This isn't leniency, it's a long-term legal pressure cooker designed to force responsibility without incarceration. So ask yourself, is this mercy, or is this one of the harshest forms of accountability the system can impose?
Pays it back, meaning if she can do larger payments, she can get off of it sooner, which is the incentivization.
So she's pleading to the charge as charged, and you're adding 2 misdemeanor thefts?
Yes.
Yes.
So essentially, she's avoiding the felony if she does pay it back over this long period, and no matter what, she's been convicted of 2 misdemeanors.
All right. But with regards to the misdemeanors, what is the agreement?
The agreement on that would be costs. She doesn't have any AODA issues or something like that to give DOC to deal with, essentially.
All right. Ms. Rawls, is that the agreement that you've reached?
Yes.
Formal motion to amend to add 2 misdemeanor thefts.
So added.
Okay, so it's under $5,000, correct? I believe it is.
I think it's under.
I think they've changed it so many times.
Excuse me.
Theft in a business owner.
Yeah, she's pleading guilty to the charge.
It's under 2,500.
Okay, under 2,500, and we're adding 2 misdemeanors. What's the statute? Do you have that?
Yes, it's just the misdemeanor theft statute. So the penalty provision is 943.23A. And then otherwise, the actual statute of the theft is the same as this one, which is 943.20 sub 1 sub B. Oh yeah, I said too fast. Sorry.
I can wait until
The statute's the same as the original offense in terms of the charge, which is 943.20 sub 1 sub B. But the penalty provision is where it differs. That is 943.20 sub 3 sub A, which is under 2,500.
And you're simply going to amend on the record. You're not going to do an amended information.
If the court prefer I do the amended information after the hearing, I can do that.
I'm going to say in cases like this, Mr. Schmidt, I'd like that because I've seen a Washburn case that I'm on blow up because they just did it on the record and it got all messed up. And that was from 2013. And so it's hard to piece the cases back together. So if you can do that, I would appreciate that.
Would the court have any problem if I do that after the hearing?
Nope, after the hearing's totally fine. I just want it for connecting the dots in case. Okay, Ms. Rawls, that is the agreement, and your attorney has handed me, well, I have two documents. One is a plea questionnaire waiver of rights form with attached theft by employee, trustee, or Bailey. I should have known you put the jury instructions because you're very thorough, and so I could have told the statute right there. So thank you, Mr. Reed. And he has the jury instructions and the other document that shows the offense and what needs to be proven. Do you recognize these documents?
Yes.
Did your attorney thoroughly go over these documents with you?
Yes.
Did he essentially go over them word for word?
Yes.
And so you understand everything on these documents?
Yes.
And with regards to the plea questionnaire, is that your signature on the second page?
Yes.
So your attorney went over with you what the state would need to prove your guilt beyond a reasonable doubt to 2 misdemeanor thefts, correct?
Correct.
And he went over with you the maximum possible penalties you face. Is that correct?
Correct.
Now, I also have the deferred judgment of conviction document with some of the terms, the more important terms were stated on the record. Do you recognize this document?
Yes.
And did your attorney thoroughly go over this with you?
Yes.
Essentially word for word?
Yes.
And so you understand everything completely.
I do.
And that is your signature on the last page.
Yes.
And with regards to the important terms, I'm just going to go over them again with you, that if the court accepts this agreement, that it would run for a period of 14 years and 8 months. Do you understand that?
Yes.
And after today's payment, you would owe $87,850.94. Is that correct?
Correct.
And you're going to make at minimum $500 a month payments, correct?
Correct.
And if they are late, if one of the payment is late, they're due by the 13th of every month. Do you understand that that's enough for the state to ask to revoke the agreement and to sentence you and enter judgment?
Yes.
Also, if you pay it off early, you can have the agreement go away and not worry about that felony anymore. You understand that?
I do.
Do you also understand that within 60 days from today, you must pay $150 to the district attorney's office?
Okay.
If you don't, that's the number one reason I see the district attorney's office asking to have these matters or these revoked and to set you for sentencing. Do you understand that?
I do. Do I pay that where I pay my ticket?
No, you pay that at their office.
Okay.
Okay?
And where's that at?
Very important.
Just on the whole.
Okay.
Very important you do that, and I would do it as quickly as possible.
I get paid Friday, so I'll do it then.
All right. So I have that you're pleading guilty to 2 counts of misdemeanor theft and 1 count as charged, theft of a business setting greater than $10,000 but less than $100,000. Is that correct?
Correct.
You're 39 years old. You have 12 years of school. You can read, write, you understand the English language.
Yes.
You are not currently receiving any treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or medications in the last 24 hours.
Correct.
Because you're charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on both of the documents on the first page. Your attorney thoroughly went over those rights with you,
He did.
and you understand them completely?
I do.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
I do.
That even concerns a deferred judgment of conviction. You understand that?
I do.
Do you understand, or do you need me to go over these rights with you in any more detail?
I do not.
You understand that you're pleading guilty to a felony. If the court accepts the deferred judgment of conviction, this won't be applicable to you if or until the court enters judgment to sentence you. Do you understand that at that time, you would no longer be able to use or possess a firearm for life?
Correct.
You would no longer be able to vote in any election until your civil rights are restored.
Correct.
Those do not apply to the misdemeanor thefts, okay?
Okay.
All right. Do you understand that here, the state would have to prove with regards to the charge that it has been charged, that count 1, theft of a business setting greater than $10,000 but less than $100,000. Do you understand that The state would have to prove on or around and between February 7th, 2023 and July 6th, 2024 in Burnett County, Wisconsin, by virtue of your employment, you having money in your possession greater than 10,000, but not to exceed 100,000, and you retained possession of that money without the owner's consent and with the consent to convert that for your own use. Do you understand that?
I do.
And do you understand the maximum possible penalty if the court enters judgment of a G felony could be up to a $25,000 fine and imprisonment of up to 10 years or both? Do you understand that?
I do.
As to both of the misdemeanor thefts, do you understand for each of the thefts, the state would have to approve, or would have to prove that you had possession of, oh, wrong one, sorry, that you intentionally took and carried away with property of another. You took and carried away that property without the owner's consent. You knew that taking and carrying away that property was without consent, and you took and carried away the property with the intent to permanently deprive the owner of that property. And this is less than $2,500. Do you understand what the state would have to prove?
Yes.
And that's for both counts. You understand that?
Yes.
Do you understand the maximum possible penalty for each of those counts could be a fine of up to $10,000 or imprisonment of up to 9 months or both? Do you understand that?
Yes.
Do you understand that this court is not bound by the agreement reached between the parties?
I do.
Said differently, if I thought that there should be something different for a sentence, I can do that in my discretion. Do you understand that?
I do.
Do you also understand I do not have to accept a deferred judgment of conviction?
I do.
Do you still wish to proceed and enter a guilty plea?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Did you review this criminal complaint with your attorney?
Yes.
In particular, there is a section called the probable cause section, and it basically says what happened throughout that time and why you were charged with the crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Mr. Reed, may the court use the probable cause section of the criminal complaint to find a factual basis?
No objection, Your Honor.
Has anyone made any threats or any promises to you, Ms. Rawls, for you to plead guilty to these crimes?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked at the defense or at the discovery, and has he discussed that with you?
Yes.
Has he discussed with you whether or not you have any defenses or a lack of defenses in this case?
Yes.
Has he discussed with you what could happen if the matter goes to jury?
Yes.
Are you satisfied with his services?
Yes.
Any questions for the court or your attorney before I proceed?
No, thank you.
Mr. Reed, do you believe that Ms. Rawls is entering her plea freely, intelligently, and voluntarily?
Yes, Your Honor.
Do you believe she understands the rights she's giving up and what that means?
Yes, Your Honor.
Do you believe she fully understands the deferred judgment of conviction and how important it is to meet every single provision?
Yes, Your Honor.
Does she understand the ramifications of what could happen if she does not meet every single provision?
Yes, Your Honor.
Any reason to believe she is not competent to enter her pleas?
No, Your Honor.
One last time, any questions for the court or your attorney?
No.
As to count 1, theft of a business setting greater than $10,000 but less than $100,000, a class G felony, how do you wish to plead?
Guilty.
As to count 2, which is now added to this case, misdemeanor theft under $2,500, how do you wish to plead?
Guilty.
As to count 3, the count that was added to this case, misdemeanor theft under $2,500, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of all 3 of those charges. As to counts 2 and 3, judgment will be entered. As to count 1, the court will hear arguments on whether or not to accept it. We are in victims' rights compliance.
Yes, Your Honor.
All right, argument, Mr. Schmidt.
Judge, these are always the hardest cases when you have an offender who at age 39 commits their first crime, and it's a really big crime. It's an embezzlement of a large amount of money from an employer that trusts them. The reason she was even in a position like that as a manager of this gas station is because she does have large ability to work and do a good job and get income. The amount of money is very large. Paying that back is a high priority, especially given the number of it. But it's too severe to just do a DJOC, which is why we have the extra convictions there. Those are her first convictions, and that will be a significant consequence to her itself, especially given what their convictions for. We really want to incentivize her to pay the money back. That's why we did the DJOC. I think she has high ability to pay in the future. That's why we're willing to do what I would wager is the longest DJOC ever done in the history of our office. We're willing to do that to make this business whole again. Another reason why we even remotely consider doing this is, this isn't just accepting responsibility here with the judge after you've been caught. She accepted responsibility when she was talking with the managers originally when they first sniffed it out. So this is really trying to restore the state of affairs back to where they were while still giving some accountability in terms of the convictions to this offender. Like I said, there's really no reason to think alcohol or drugs or gambling or any of the vices we typically see as drivers of criminal behavior here. The only thing the defendant alluded to when she was interviewed by the managers was issues relating to her son. Thank you.
Fines and other stuff. And that's what I don't understand is $87,000 and change is a lot to pay fines and stuff. So, but I'm hearing, at least from you, that there's no underlying issues to be concerned about as gambling or
Nothing like that.
addict who shops, a shopping addict.
And you have to remember, this isn't taking $88,000 off the till. This is over a very long period of time. Something you commonly see with most people who commit embezzlements is they have no clue how much they took until someone like adds it up and shows the receipts later, and they're like, oh my God, I took that much. So it's not uncommon to see this.
But it can't just be for fines and stuff.
I couldn't say. All I can say is it can't be traced to vices.
All right, Mr. Reed, argument and sentencing recommendation, please.
Thank you, Your Honor. I'm asking the court to follow the joint recommendation because I believe under the Galleon factors, it's appropriate. This is a serious situation, Your Honor. It's a G felony. But I believe the public is better protected by Ms. Rawls working to make the victims whole. This is a case where she's worked hard to get the money that she's put into the clerk of court's office already. She's made a promise to make these payments. She's worked with prior counsel and current counsel to figure out a way to make the victims whole here. So I think that the community is protected by this. I think this is very serious. I believe that incarceration isn't going to help Ms. Rawls. Jennifer isn't going to help the public if she can't work to make the victims whole here. So I think under the Galleon factors, this joint recommendation is appropriate. Again, these are her first convictions.
This is the emotional core of the case. The judge isn't questioning whether the theft happened, that's already established. What she can't reconcile is why. No addiction. No gambling. No lavish purchases. Just repeated withdrawals that quietly added up to nearly $90,000. And here's the reality the court is emphasizing: even when the victim is a corporation, the damage doesn't vanish. Prices rise. Communities pay. Trust breaks. And once that trust is gone, it follows a person into every future job interview.
On this case to work towards making the victim whole. So we're asking the court to follow the joint recommendation because we believe it's appropriate given the factors, Your Honor. Thank you.
All right, thank you. Ms. Rawls, this is your opportunity to provide any statement to the court that you wish. You don't have to, but it's your only opportunity to tell me anything that you think I should know or be aware of as it relates to this matter and to sentencing, okay?
Okay. I don't have anything to say.
Okay. Again, I don't understand how $87,000 or $88,000 was used to pay for fines and stuff. That's a lot of fines and stuff, even if it's over a course of multiple years, as we have It's just 1 year. Well, it's February 7th, 2023 to July 6th, 2024. That's a whole lot of fines and stuff. And if you look at that, that's approximately $2,300 each time that was taken, because there were 40 times that have been found that you were taking or that you took money. So I'm just trying to wrap my head around this, because this is a very serious crime. That's a lot of money over the course of that year, year and a half. It's a lot of money. I'm not being told that you have any vices, you don't have any addictions such as gambling or alcohol or any drugs. I've not heard that you have any like shopping addictions, or that there wasn't one huge lump sum and you went and bought a car, something of that. I'm not hearing anything. That's why I'm having a hard time understanding. And I did read in the information I get that you were concerned about your son and you wanted to prevent him from going to prison. I don't know what he did. I don't know if it's $88,000 worth, but that's a lot. So this is serious, because this is a lot of money taken from your employer. And I know some people would look at this and say, it's a gas station, it's a corporation, they have money, they lose money all the time. It's not like I stole the money from church. It's not like I took the money from my best friend. We've had all of those cases. But taking money, especially this amount, from a corporation is still wrong, and it's still a crime, and it still hurts. It may not hurt their end books, their year-end books, but it hurts everyone in this room, because with the theft and that amount of money, they have to increase prices on all of their things. So consumers pay. So again, that makes this more serious. When I look at your character and your past criminal record, you don't have one. It sounds like you have a good character for the most part. You wanted to help your son out. You wanted to make sure that you were being a good mom. You were working. But with the thefts, it leaves a little bit of concern with credibility and trustworthiness. I don't have anything that says that you are in need of going to prison or even serving time in jail for this at this time. The number one goal in cases like this is restitution, making the victim whole, making sure that they get all of the money back that was taken. So that's why a deferred judgment of conviction is appropriate in this case. And I can see that, because if you're in prison or if you're in jail, you cannot work, you cannot pay this back. In prison, I think they get 15, 20 cents an hour. You'll never pay it back. So this is a good plan. And hopefully you're going to be able to make payments above $500 a month, and you can have this felony off of your shoulders, and the victims would be made whole. And in the end, everybody wins, and you still have punishment with the 2 convictions. Because you're 39 years old, and now you're a criminal. Now you have convictions on your records that can't be hidden, and they're thefts. That will continue to follow you, and it will continue to follow you with each and every employment that you engage in. That's unfortunate, but you brought this upon yourself. When I look at needing to protect the public, that aspect, I don't need to protect this victim anymore. You're no longer employed there. I just need to protect this victim in looking at getting that restitution back. I can't protect your other employers, because I don't know where you work and I don't know where you're going to work. So as of today, I can't do that or look at that. This is a crime, but it's not a burglary. It is a theft, but it's not a burglary, which is violent. It's not substantial battery. It's not engaging in disorderly conduct when you are very intoxicated on substances or alcohol. And I've been on enough cases like this to know that what Mr. Schmidt stated is accurate and true. When a person engages in this type of theft and they take it here and they take it there and they take it again there and here, it doesn't compute in the brain how much it adds up to. Because I'm guessing when you saw that 88 and some $1,000, you went shock. And you're like, oh my God, that can't be true. That can't be accurate. How was it $88,000? And you're shaking your head up and down, yes. And then the impact of this is huge. It's affecting you. It affected the community. It affected the gas station. It's affecting your kids. And it will affect your future employment. With regards to this matter, again, in hearing the arguments of the council, of both council, and knowing the number one goal is restitution, I will accept the deferred judgment of conviction for that felony. You're going to be given a second chance with the felony matter. With regards to the 2 misdemeanor thefts, I can't follow that recommendation. Because even though you are not appearing to have substance abuse issues, you're not appearing to have other criminogenic needs, that's what, I don't know that. And I don't know why all of this money was taken and what it was for. Only you know that. And maybe, I don't think Mr. Reed even knows that. Because if Mr. Schmidt doesn't, it's not in the discovery. Only you know why. Because again, having a hard time thinking 88,000 is fines and stuff. So I am going to place you on probation for a period of a year. You should have some supervision. You should have some understanding of the severity of this crime. Conditions are going to be absolute sobriety. No alcohol, no use of any illegal substances, no paraphernalia, no medication without a prescription. I'm going to say drug testing and your agent, drug and alcohol testing, your agent can determine when and how often to do that. I am also going to say that at least for the period of this year, you must inform every employer what you did. They deserve to know.
My employer does know.
I'm glad to hear that. You're
let
being
them know.
upfront and you're
Yes.
being honest. And that tells me, again, you're owning this.
Yes, I did let them know and talk to her specifically about it, so.
I'm very glad to hear that. So if you change jobs, though, you have that condition, you have to let them know and update them on the matter. I'm going to say gainful employment because you need to be employed to pay back that restitution. Any other programming that your agent deems necessary. I'm also going to say a mental health evaluation. See if you need some type of therapy or what's going on. Because again, I don't know exactly what's appropriate here because I don't know exactly where the money went. Okay. And so I don't know if you are struggling with issues. I don't know if there's things that you need to deal with. But having the evaluation will say if you need any further treatment or something.
This is the emotional core of the case. The judge isn't questioning whether the theft happened, that's already established. What she can't reconcile is why. No addiction. No gambling. No lavish purchases. Just repeated withdrawals that quietly added up to nearly $90,000. And here's the reality the court is emphasizing: even when the victim is a corporation, the damage doesn't vanish. Prices rise. Communities pay. Trust breaks. And once that trust is gone, it follows a person into every future job interview.
Even if it's just a DJOC, when there's restitution involved, and I make sure that restitution gets paid. All right? Because it needs to be paid. But you have the hammer over your head of, if you do not pay, judgment will be entered and you could be sentenced to prison.
Right.
So I'm going to sentence you to 9 months, the max for both of these consecutively. So that means 18 months in jail if you are revoked off of probation. So this is your year to shine. This is your year to do all that you need to do to prove who you really are and that this isn't you and it should not define you. And it also ensures that at least you're going to understand the seriousness of this and you're going to do what you need to do and pay it back. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, which are $443 per misdemeanor, you fail to pay that, and payments are going to start now. You're going to have to pay this restitution. You're going to have to start paying the payments for the fines and fees. It's going to be a double whammy, but you're going to have to do it and figure it out. You pay the restitution to the district attorney's office. You pay the fines and fees to my clerks. Okay. So with regards to the matter and how much is owed, that would be a total of $886. I don't know if there's anything on top of that. They have some surcharges that they may add. I don't know. You're going to have to make payments of at least $100 a month.
Okay.
Okay. I don't want to make it too high, but I don't want to make it too low either. You need to understand the seriousness, and that's where this punishment part comes. And so you'll have a total of $600 to pay, $500 to the state, $100 to the clerks. Okay. Until paid off in full. If you fail to pay, a civil judgment will be entered against you, and you could sit up to 6 months in jail. So if you're going to miss a payment for some reason, you have to let me know, and have to let me know why, so I can make a determination of whether or not you can miss a month.
Okay.
If you miss a month and I don't know anything, a warrant will be issued. You will sit jail. Okay. So it's very important you pay that too. Mr. Schmidt, what am I missing?
I don't know if this is for a question for you or for Madam Clerk. Do we need to put anything on the JOC to indicate our office is collecting?
Well, I can put it on the JOC for the misdemeanors and then.
Yeah, it'll be clearly identified who gets what.
Okay, perfect. That's all then.
All right. Anything from your perspective, Mr. Reed?
No, Your Honor, thank you.
Oh, yes, I have to order DNA. So that means you're going to have to go to the sheriff's department and provide the DNA. With the misdemeanors, you would have the ability to request the DNA be expunged from the system, from the CODIS system, if you know what that is, through a written letter to the Department of Justice, not to this court, to the Department of Justice. You can Google it. It's pretty easy. As to the felony, if the court enters judgment to the felony and you are sentenced, you will need to make sure that your DNA will need to probably be taken again, because that will not be able to be expunged because it's such a high felony. Okay. All right. I think that's it. Make sure you go right to the jail, to the receiving, and you provide your DNA, and then you're free to go pay the $150 within 60 days and start making your payments. Okay.
Okay.
All right. Thank you. We are adjourned. Oh, yes, I'm sorry. And you have to report to probation because it's 4 o'clock now. I'm going to say that you have until tomorrow at 4. What do you work tomorrow?
I do work tomorrow.
What time do you work?
10 o'clock.
Until when?
8 p.m.
Okay, so you have to report tomorrow morning before 10. They're open at 8 or 8:30.
Okay.
So go report, make sure that they have your information. And you're still on Park Street?
Yes,
3081 is your telephone?
yes.
All right, thank you. Then do that tomorrow morning.
Okay.
Thank you.
I do have a doctor's appointment tomorrow morning. Is there any way I can maybe talk to my work and go in there before I work? I have a doctor's appointment at 9:30 in
What
Frederick.
about Wednesday?
Tomorrow is
Oh,
Wednesday.
I'm sorry. My days get all mixed up.
Thursday I don't work until 1.
All right, so you have Thursday until noon
Okay,
to report to probation,
okay,
okay?
perfect. Thank
All
you.
right, thank you. We are adjourned.
Thank you, Your Honor.
Thank you, Mr. Reed. It's always nice to see you.